Think about it like collective bargaining. This group of employees is making proposals to an employer, and the employer has the ability to either say yes or no to those proposals. That is like collective bargaining. It's called an unfair labor practice. The employer could have to disband that group. Now we're definitely getting into thin ice.
Welcome, everyone. Super excited for this session. This session is months in the making. For those who don't know, my name is Maceo Owens. She, her pronouns, all things ERGs, so much so that I go by the ERG Homegirl here on LinkedIn. Part of my love for ERGs is making sure they're set up for long-term success. And there's a lot of work needing to be done in the space right now to make sure that is true. One of the aspects I've been looking at recently is the legal aspect from ERGs. And obviously, I am not a lawyer, and this is something I've been repeating multiple times for the past couple of months. I do like to talk about things based on what I actually hear from lawyers. We've had conversations in the past, like Tiffany Thomas, who talked about discrimination and how some ERGs might be violating the law. Today, there are some other things, specifically unions, which I think in this space is something we don't talk about often. A lot of program managers probably think that there is no intersection or anything we should be concerned about with unions. I beg to differ. I had a hypothesis and then I went on a hunt. I was like, others have to be able to tell me if this is true or not. And that is when I encountered Phil Wilson. I'm actually going to bring our special guest here to the stage because, as mentioned, I don't like to just talk about what I think is true. I want to give you all the actual facts here. So, that said, Phil, I want you to introduce yourself. Tell us like who you are and what you do.
Sure. Well, first, thanks for having me on. And like you said, this has been months in the making, mostly due to my calendar. It's great that we finally made this connection, Maceo. I'm excited to have this conversation. I want to learn some things from you too. So, quick introduction, my organization's called LRI Consulting Services. It was started by my dad 47 years ago, and it's our family business. What gets us out of bed in the morning is helping our clients create extraordinary workplaces. We intersect with companies around labor relations issues. LRI stands for Labor Relations Institute. I'm a labor attorney, and we've done a lot of work over the years with companies, but our end goal is to help companies create extraordinary workplaces. The companies that do the best job of that are places where people feel like they belong or feel included. A lot of the work that ERGs have done and that you support is the same kind of stuff that we tell clients, irrespective of audience. You got to create the kind of workplace where people feel safe and comfortable and there's psychological safety. Those are the workplaces that are the most successful, where people are most engaged and are the best places to work. We have this kind of labor relations backdrop to everything we do. We intersect with companies when they face labor relations issues. That includes unions trying to organize those companies. When you and I first met, I hadn't really thought a ton about how ERGs are a little bit like unions, or at least union adjacent. It's a group of employees working together on a common workplace issue, which is adjacent to what unions do. That's a fascinating way to look at them. So anyway, that's how we met, and I'm really glad you found me on LinkedIn. We've had a chance to talk about it. Now we're going to talk to your audience about it.
Yes, because definitely when I talked to you, some mind blowing things that I heard. And it's interesting because there's two situations. So when I talked to you, it was time I had this concrete thought that there might be some kind of overlapping here when it comes to ERGs and unions. I was actually speaking to someone who was writing a book about unions, and she didn't know much about ERGs. I didn't know much about unions outside of the fact that I live in Michigan. So, I mean, there's definitely a lot of unions that I'm surrounded by. That said, she
Go
was,
blue. I went to Michigan, so that I don't
I
want to
love
start.
that.
I don't want to start a big fight, but anyway, that yeah.
Right, right. I don't know if there's any Ohioans on this call, but I will say with that conversation, she interviewed me essentially for her book because she wanted to talk about how ERGs can really help push union work forward. I was kind of confused with that because I don't think that that would be the best positioning for ERGs, but I couldn't really explain it because I don't
Mhm.
know that much about it. That
Yeah.
said, coming from you, What would you say is the concern when it comes to the possible overlap? Like, what would be so bad? Even kind of what she was proposing, ERGs pushing union work forward, or even being like amateur unions that could eventually develop it.
I write a lot about leadership. Behind me is my latest book, The Leadership Playbook. I work a lot with our clients around creating great workplaces. That starts with great leadership. What I would say about where ERGs fit into that and how it relates to unions, ERGs are a substitute. The reason why people seek out a union is they want to interact differently with their employer, right? The state of nature, that interaction is I work directly with my management, and if I've got a concern or if there's something that I think could be better at work, I go to my leadership and I go, hey, like, I don't like the way that this works. Can we talk about doing something about it? And then management, in the ideal state, listens to that concern and is like, oh, we hadn't really thought about that. Let's talk about how we could fix it. And then they fix it. Great companies do a great job of doing that. They listen, they try to quickly act and respond whenever there's an issue like that. Not everybody's the best company. And so some companies do a poor job of that. Some companies do an absolutely terrible job of that. And if that's the situation, then at some point people either quit. Like the best people just quit. If like people who've got like good options are just like, I'm fed up. I'm going to go work somewhere where they listen to me. But not everybody has that option for a lot of different reasons. This is where I grew up. There's not a lot of better jobs, and I'm committed to my life here, my community. I'm not going anywhere. I want the company to change, and I want it to be better. If you're in that spot, you are looking for alternatives to voice. A union is a common place that people would turn to in that situation. In between that is the space where ERGs fit. It's not just ERGs, but it's also we'd like to get a group of our employees together to work on a particular issue or concern with the company. That can be a work-related project, but sometimes it's very culture-related. We want to have a team that comes up with volunteer activities that we do at the company, or that does, like parties, or other topics. So that's, to me, is the space where ERGs fit. It's an answer to a concern that a group of your employees are like, hey, we feel like this need's not being met, and we would like a place where that need can be met. Good companies go, oh, I think we can help do that. Like, let's create a ERG group that folks can work together, understand each other, and communicate back to us. What are some of the issues they see where their group doesn't feel like they belong or understood, or all of the things that ERGs do to communicate to the company. Unions are very different than ERGs. Some people think about a union almost the same way you would think about an ERG, which is like, this is a group that I belong to. I feel like I'm my full self and I am supported by this group. So in some ways it can fill that same thing that an ERG might fill for people. But as a legal matter, it's a very different thing. There's a legal obligation to bargain with that group. And unfortunately, many times that's an adversarial relationship. And so it's in this different place than ERGs are. That's how I would map out the territory. Let me pause there. I know one of the things we want to talk about is, could an ERG be seen like a union? Before we get there, why don't I pause if you've got any questions or any of your own thoughts about that territory I just laid out.
This makes sense to me. I do think it's important to state for those who might have missed it that this is not just an ERG thing, but any employee group, even a safety committee, a culture committee. There's different forms of employee groups that are meant to make the workplace better to some degree. So I find that interesting. Some people might say, well, this is a conversation coming out of the political climate, but these are things that apply regardless of what the committee's focus is, essentially. I think that's important because that was kind of a shocker to me. And it almost reframes ERGs just in general, because I don't think a lot of people come at it from that angle, but really a group of employees who are here to make the company better for other employees. Like, as a baseline, that's what we do. That's a good tone setter. According to the landscape, unions kind of, their thought process is the same concept, like group of employees trying to make the workplace better, but typically there's a tension about how that goes about. There's a lot of legal obligations, as you mentioned.
Yeah.
Then the question is, what if someone said there might be a lot of legal obligations, but is that a bad thing? Like maybe it's good that now the company will be legally obligated to go back and forth with an ERG. So I guess that would be the follow-up, which I'll probably state like, obviously ERGs wouldn't want to have an adversarial relationship with the company.
And to be clear, not all union company relationships are adversarial. They do tend to be, and that can be because of both sides. A union, they're justifying like, you need us to voice for you. And many times it's like, you need us to protect you. Well, who are you being protected from? It's the bad employer. And that's a very easy spiral to get into. And then if the company is dealing with this group that's like, oh, you guys are all terrible, that doesn't really make a very happy relationship. So it does often become adversarial. And a lot of times the way unions get in the first place is by saying, this is a horrible employer and you need us to protect you from this bad employer. So that's why it tends to be adversarial. And you're right, ERGs tend to be on a very different footing there, right? This is not us fighting with our company. This is our company helping us have a safe space to support each other, which is very different. You and I talked about the legal framework here. If you have a group of employees dealing with their employer, it's a squishy concept, right? If you think about it like collective bargaining, this group of employees is making requests or making proposals that we think you should be doing things like this. The employer has the ability to say yes or no to those proposals. That is like collective bargaining. And that group is like a union as far as the statute is concerned, like a group of employees that are negotiating on behalf of that group or negotiating on behalf of all employees. That looks and feels like a labor organization, is the term in the statute. And employers are not allowed to dominate or even to negotiate with a employee group that has not been voted in or recognized as the majority representative of that group. And so that's an unfair labor practice. And so that can cause that group to be disbanded. And the employer has to promise, like, we won't deal with that group like that anymore. That's framework that when you apply it to ERGs, you're kind of like, oh, come on. But I could certainly imagine situations that if the ERG is set up in a way where the employer is resourcing it, this group of employees is asked to represent the views of that group and make proposals, and the employer can accept or reject those proposals, that is probably an employer-dominated union.
And when you mentioned that to me the first time, I was shocked, but also confused, because I was like, an employer-dominated union, I'd never heard of that. You mentioned a statute. So what is the statute around employer-dominated unions, and why is that? Why should people be concerned about that in general?
Yeah, well, the statute is the National Labor Relations Act that governs all of this area of employers dealing with labor organizations. The thing that people don't understand, a labor organization is not just the United Auto Workers or the Teamsters. Like, a labor organization is any group of employees representing their views to an employer that are engaging in what's called protected concerted activity. That's why a safety committee can be an employer-dominated union if it is set up in the wrong way. Going back to ERGs, if you are saying these are the only people that can be in this group, and one of their roles is to represent the viewpoints of that group and to present things to us to help that group, that is very much like a union, right? Versus anybody can be in it, it's voluntary. That group doesn't represent, they're not there as a representative of the group. The resource to them, going back to the original idea of ERGs, to me, is more like a community where folks that are interested in that community can go and network and support each other. I think they morphed somewhat into more of this representative place. And that's where you start touching the boundary lines of labor law. But if you go to sort of like anybody can be a part of it, It's not really designed as a negotiation vehicle for this particular group. That's now further away from the boundary lines of employer-dominated unions.
What is the worst case scenario of what could happen if a company was found to have an employer-dominated union?
Well, it's called an unfair labor practice. It could be disbanded. So whatever that group is, the employer could have to disband that group. If the employer is providing resources to that group, you're no longer allowed to provide resources. The employer could be prohibited from whatever back and forth was happening with that group. The statute is called a remedial statute. Its goal is that if anything was wrong, the remedy is to get things back to the way they were before this bad behavior happened. So if the problem was that the committee is employer dominated, then whatever employer domination was occurring, stop that. That would be the typical remedy. In extreme cases, if there was a claim that a group of employees was deciding to organize a union and the employer in response said, we'll create a bunch of these employee resource groups, or we'll create an employee resource group, hopefully that will discourage people from unionizing. Or in like worst case scenario, they go, well, look, instead of unionizing, why don't we create this employee resource group, give it a bunch of resources, and then you guys don't need a union. That would be an unfair labor practice. The remedy in cases like that could potentially be you're forced to recognize the union. So whatever union was trying to organize, you could be forced to recognize that union, and everybody would be represented by that union as a penalty for using the ERG is like this sort of bribe to get you to not organize a union. So that's the range of penalties. The case I brought up is very extreme. I'm not sure employees would fall for that ruse, but it could happen. Generally, the risk is either resources are taken away from the committee or the committees are disbanded.
Okay, so we do it right, or we might not have it at all, which is fair. That pretty much falls within most legal frameworks. Even then, I'll ask more about employer domination, but let me know if I'm correct. This only really applies if the group is in that union adjacent space. If it's more so just like a culture driven, internal community types of program, that's not a concern for the company to be governing. It's really only when it's touching these like union type of conversations.
One trick you'll hear from labor lawyers is like the answer to every question is it depends. Generally, the further you are from this group dealing with the employer, the safer ground they're on. And I do feel like, Maceo, one of the things I should be clear about, I think that this rule in the law is dumb. Like, even if you are strongly pro-union and you feel like unions should be in every company, this employer domination of work groups and prohibiting it and restricting the way that it happens is very counterproductive to people that want to organize. Like those committees, if employees are participating in a representative capacity, that is a baby step toward a traditional exclusive collective bargaining relationship. If the employees and the employer are doing that back and forth and it's working well and everyone feels their needs are being met, then maybe they don't see a need for a union. Unions may not love that, but if your goal is for employees to feel like their voices are being heard and the employer is responding to their needs and concerns, at the point that you start like objecting to that, you're just going like, no, we should just get paid dues for that. I don't think that's very strong ground to stand on. But the flip side of that is if that kind of committee dealing with the employer isn't really meeting the need, the logical next step is to go to collective bargaining. And so I think if you get rid of this whole employer dominated union thing, you are also creating an environment where unions long-term probably are more successful. But that's not how most people see it. And reasonable minds can certainly differ on that point. That's a section of the statute that we're talking about. Mm-hmm. But this whole employer dominated thing, I don't think is really good for employees. It's confusing for employers. And I don't even think it's good for unions, but it's the law and we're stuck with it.
This is helpful to hear. And I think that hopefully answers your question. I want to make sure I'm pronouncing your name right. Nija, I think Camille's question here is still relevant because the reality is a lot of folks are doing things that are in the union-esque area, which we can clarify what those things are. But I know one of the ones that come to mind almost immediately is like helping to push for more inclusive policy and more inclusive benefits. To me, the initial thought is that it's kind of concerning. Before really doubling down on your question, what are some of these things that ERGs probably should not touch on? What are the union-esque things in the first place?
It's a great question, Camille. If there's not a traditional union, the employees in the ERG are getting their needs met are not going to complain about it, right? The way this gets complained about is if you have another group, and that could be a different group of employees or a union going, we want to stop whatever's happening with the ERG. So part of this becomes just an assessment of, is that even a concern around here? The thing I would say, Camille, is you have benefits, wages, the way promotions are happening. The things that unions negotiate about are wages, hours, and conditions of employment. So if you're talking more about those types of topics, then that's where you get closer to the line of dealing with an employer. If you're dealing with culture, support, and network, I think you're further away from that. Even if you are proposing to the employer, like, have you ever considered this change in the way we do things because it would better accommodate this particular population? That's different if it's not dealing with wages, hours, and conditions of employment. Even saying we bring up this one benefit that we think would be great to add for this population of our employees, and that's not like the regular discussion, but it's something that comes up, I think that's less risky, a regular back and forth about wages, hours, and conditions of employment. So, again, going back to the labor lawyer answer, it depends. These would be super fact sensitive, and it's going to really depend on the situation. But I would just say for managers of ERGs and for folks that believe in this space, and it's important, I know this world is completely on fire right now, which is sad. I think employees deserve, like, going back to what makes a great workplace, places where they feel belonging, included, and heard. That's what great employers do. The sad thing about where we are right now, if you look at the glass half full, this is probably forcing ERGs to be more inclusive than they would have been before. And maybe it is sparking conversations around the benefit and the value that we're getting out of these. I feel like those are productive conversations. I just hate that if it's an ERG about race, then it's like put in this different bucket than an ERG about like some other affiliation. But all that said, those would be the things, Camille, that I would be looking at. I would say the warning bells go off when it is looking more like a back and forth over wages, hours, conditions of employment.
So just to give an example that I see oftentimes when it comes to a parent's ERG, for instance, maybe they want to advocate for longer parental leave. They've put together a proposal as an ERG. They have member feedback on it, and then the ERG leaders present this to HR. At what point would it become like, we're getting into bad territory? Maybe it's from the beginning, but at what point within that HR says, we're not ready at this time to extend parental leave? And then the ERGs, the leaders, they talk to their members, and then they say, we want you all to hear from us, and maybe we can come to some sort of conclusion.
There's a protest of some sort about your stance on parental leave is not fair. That gets squarely into concerted activity. It's protected, how the employer responds. There's a right and wrong way to respond to that. That you've just explained. Talking about parental leave, not probably a big issue. Presenting a proposal about parental leave, now we're definitely getting into thin ice. The company responding to this group with a yes or no, that's definitely dealing with. And you're dealing with the group, not with individuals representing themselves in their own personal situation. They're saying, we as a group think you should do this. And you're going, we reject what the group wants. That's very much like collective bargaining. So I think that is a great example of where it starts to butt up against the labor laws. And then if the group wants to protest and object about it, that's definitely protected activity, and it's covered by the statute. And that now starts to really feel more like a union.
Okay. This is helpful to hear. Sometimes people just need to hear it, frankly, because I mean, there's actual books about ERGs that tell you to do these things. And I learned about this. I was like, This is concerning. Shannon has a question, two of them. We can address both of them at the same time. The concept of advocacy as it refers to ERGs, and oftentimes that might be a pillar of an ERG program strategy, is to advocate for employees. What's your initial reaction to the thought of an ERG program saying part of what you all should do as ERG leaders is advocate for the communities that you represent? What would be wrong with that statement?
I'll just give you my knee-jerk advocate. Advocate to me seems a little bit more like this group is going to propose things. And ideally, individuals are making proposals or suggestions. The group might be a place where individuals can talk about these different things that would make things better, that we could improve. Companies have other ways to solicit feedback. And if the company is soliciting feedback from a group or even from all of its employees, what kinds of changes in our benefits would be most valuable to you? And a bunch of people go, we want parental leave to be better. That's different than going to a group of people and saying, propose to us what you think we should do about parental leave. I think advocate would be a good word to really be paying close attention to and maybe strike that. That doesn't mean that the individuals in that group can't advocate, right? Everybody has an individual right to advocate on their behalf. You can also advocate collectively if you are on the union side of this. This in between space is tricky space.
Advocate along with any mentions of pushing for more inclusive wages, hours, and conditions of employment.
Proposals, if there's anything in the founding documents that deal with proposing things and anything that relates to wages, hours, conditions of employment, those would be kind of like the hallmark things that get you into this discussion.
But I think it addresses that in terms of if it's really culture-driven programming, it's further away from union-type things. However, as I've been talking about this conversation, which never usually talked about in the ERG space until recently, some other companies, you hear something, then you kind of form conclusions. One of the things that was said, I just don't think that they did the research, was that our ERGs should not have any formal policy created by the company because that would make it employer dominated. Would you agree?
It's a fact specific situation. If there was an unfair labor practice that was filed saying like this ERG, is an employer dominated union, the kinds of facts they would look for would be things like, did the employer write the charter? Did the employer set the ground rules? Like, hey, the employer's like, we've got this great idea and here's the budget that we're going to give to you for this idea. And we want you to meet this many times and quarterly present us with a list of things. So that's employer dominated, right?
Right. Most companies do those exact things. We give exact budgets, we have meeting cadences. The only reason we should be concerned is if we're also doing those adjacent things, wages, benefits, working conditions. And that's when it's concerning.
Maceo, I also, just to add another complication, you brought this up and I should have said it then, but the act applies to non-supervisory employees. If the people involved in the ERG are all management, just assume there's this group called management, and the management group is not protected by the statute. The rules are different dealing with a management group than it is if you're dealing with a non-supervisory group. So if there's no non-supervisors in the group, a bunch of these things we've talked about really don't apply. Now, to me, it's like, why would you limit the group to only managers?
Right.
I think you would encourage and want non-management folks to participate in the ERG. That's another sort of complication.
Got you. It's an important one to know. It's a technical loophole. Another question coming through in the chat. I do want to double back and state this explicitly and make sure that folks hear this. So you're saying as individuals, we can give feedback to the company around those topics, but that's not something that an ERG or especially ERG leaders should do on behalf of their members, right?
I want a raise. I want better parental leave. That's how things work in good companies. And so that is what we call a direct relationship, but that's where you're dealing as an individual directly with your management. Okay, that discussion, that's not illegal. It's when you are dealing with it as a group. Just to be clear, a group of people going, we think the parental leave law should change or the parental leave policy should change. That's also protected activity. You as a group can advocate on your behalf and could protest on your behalf. And the employer might, after that, go, yeah, you know what? Let's change the parental leave policy, but it's not a back and forth negotiation. Groups of employees can advocate on their behalf, but an employer is not allowed to give that group resources and is not allowed to have a back and forth negotiation with that group, because now you're dealing with a minority union. So they would either need to be represented so you can have collective bargaining negotiations, or deal with us as an individual.
Hopefully that answers some of the questions here. I did miss one. This one's from Lola. Shouts out to Lola, really huge advocate in the ERG space. I guess nowadays, let me stay away from using the word advocate just so people don't get it confused. But
I'm not trying to like rewrite the playbook, but anyway.
It probably needs to be rewritten, honestly. So around the coexisting of ERGs and unions, I've seen it, but I see a lot of things. What would be your immediate thoughts if a company had both a union and an ERG? What would be the things that they should be cautious around?
Yeah, I think they can coexist. The ERG still cannot negotiate with the employer. That would only be the union. All the stuff we've been talking about that is unlawful where there's no union still violates the law, even when there is a union, because now you're negotiating with a group that's not the bargaining representative of the majority of people. And I haven't gotten into the weeds, but what is an appropriate group that can unionize is a whole other subject. There's certain groups that are kind of like, is an ERG actually organizable as a union, would be an interesting discussion point. The way that works is a union can pick whatever group it wants. The test is, does this group share an overwhelming community of interest with other people at that workplace? And while you can say they share a community of interest with each other because of this affinity or affiliation, the way the law looks at it is by job classification. It's normally done by work positions. But going back to the question, what I would say about can they coexist? I think yes, they can coexist. Should they was the other question. I don't know why they shouldn't. I mean, if there's value in the ERG and there's value in the union, why shouldn't they? I could see a union maybe not wanting the competition, but I would guess in most cases, Maceo, you tell me, you've got some experience with it. I would say in unionized locations where there are ERGs, the union is probably supportive of it. Is that your experience?
Yeah, I mean, I haven't seen any tensions there, except for the fact that most places that have unionization happening, that's typically with their frontline workers, which is another reason why I have to have this conversation. More people want their frontline workers to get involved with ERGs, but then that's why sometimes they're hesitant, because they're like, well, what about unions? I think that in general, I don't really talk about this that much, but I will in the future once I bake out my thoughts. But I don't think frontline workers are as interested in ERGs just because it's a different working experience. My husband, he's a firefighter. They have a union for the city. Even viewing ERGs adjacent to unions, maybe from a frontline experience, it's like, they both exist. I don't necessarily go to every union meeting. It's just something that I'm inherently part of. Yeah. I don't think that there's the same appreciation for what ERGs are. Not in every case. This is for me, who was a frontline worker when I got involved in ERGs. From the company I'm thinking of, they had to make sure they were on good terms with the union. It wasn't a problem with the one that did already exist.
It's super dependent on what kind of relationship does management have with union leadership, and there would be and those become very individualized sets of circumstances. So really going back, I'm not sure, I can't remember her name, but whoever asked the question, what are the specifics of the situation? I think that's really kind of the question. I guess I answered, should they? I don't see why they shouldn't. It just comes down to, are they each providing value?
Which is fair. There's another question, which is probably the most asked question I've gotten from folks. And this is when I was like, I definitely just need to have Phil on a call because I can't answer this. So I'm literally like, I'm not a lawyer, but I'll get an answer for you. Okay. The question here is around focus groups. And this is another common thing when it comes to ERGs. The question is, what if an ERG isn't proposing an idea, but HR comes to the ERG to get feedback, benefit, or a working condition or a wage type of related thing?
Great question. I think that's more like doing an employee survey or just employee listening sessions, which I highly recommend. We recommend that to our clients. The more listening that you're doing, the more that you're learning, the more that you can act on the suggestions that come out of those meetings. And that is different than we have this standing committee to do it. So in that particular scenario, I would say if the purpose of the ERG is to give us focus group feedback about things that group wants, that starts to look more like a negotiation. But if you kind of schedule employee listening, and there's all different ways that you can schedule employee listening, right? You can randomly select people to come into a meeting and do a focus group session. You could do it department by department. Doing it with the ERGs seems like just another department. It's like, this is another group of our teammates that we want to listen to. I think that's okay. Even when you're doing those listening sessions, and this is where an ERG gets a little bit different, it would be the same thing as doing the shipping department. If you're going in and listening to the shipping department because you are wanting to come up with proposals back and forth about stuff for shipping, that's a negotiation, right? If you are going to the shipping department, talking to a group of individuals that happen to have the job shipper, and they are individually expressing to you how they're feeling about things at work, some of those things might be like, hey, I've got an idea of this would be a cool benefit, or have you ever thought about changing this thing on this machine? That is appropriate and proper and lawful listening and responding to individual concerns of your team. The boundary line becomes, we have this representative group of people. We've selected 5 shippers out of our 100 employee shipping department, and they are the representatives of shipping. And then we're going to meet with them on a regular basis and have them tell us the concerns in shipping, and then we're either going to do what they ask or not. That's an employer-dominated union. If instead you are meeting with randomly selected individuals from shipping to hear individual concerns from that group of employees, that's different, right? It could even on the outside sort of look the same, but it makes a big difference on whether this group is representing just them individual selves, or are they representing, the other like-minded people or similarly situated people.
Gotcha. That is helpful. And I hear this a lot. Again, that question came up a lot over the past couple of months. And I have seen even some companies that are super concerned around unions still do that, where their team might say, should we add this to the restroom? I've seen it exist, essentially. That's good to know that that is not the concern. The concern is if it's in the reverse, where the ERG is coming to HR, correct?
Or if the ERG is there to represent the group of whatever the ERG community is. We're not all of the community, but we are like the chosen representatives of that community. If the leaders of that ERG group are the people that we talk to hear proposals of things that relate to that group, that's where it becomes more of this 882 problem. They're not representing themselves as individuals, they're representing this group of people and proposing things on behalf of that group. That's a lot more like a union.
Got it. I did see a question. So there's 2 parts to this question. If things get disrupted due to a labor dispute, like a strike, how can ERG program managers manage participation and engagement? Once the strike is over, employees might feel less motivated or interested in things like ERGs, depending on how the negotiations go. I definitely have tips when it comes to engagement, but also because you work with companies with the thought process in general of making a good experience, probably seen that after some things didn't go as planned, there might be low morale. What are your initial takes from what you've seen in the space?
Well, a strike is an awful experience for everybody involved. Management doesn't like them either and tries like crazy to avoid them. And it's terrible for the people that are on strike. There's a lot of hard feelings when people come back from a strike. People lose money, and it's very disruptive. It fractures a workplace. Companies at the end of a strike, and we work with them in this situation where it's like, okay, how are we going to rebuild the relationship with our team after this is all over? And there's a lot of different things that you can do. One of those things, and I can't think of a specific experience, would be ERGs, right? The message, and it's not just a message, it has to follow the talk, but it's got to be, look, that was a bad experience that we all just went through, and We are now on the other side of that experience. There is nothing gained by worrying about what happened in the past. We have an agreement. We've all agreed that this is how we're going to work with each other go forward. And now our commitment needs to be on both sides. Our commitment needs to be to do the best that we can to get past the strike and work together and be successful. At the end of the day, fighting each other and being at each other's throats does absolutely nothing to take care of our customers and to help us have a successful business. The worse the company does, the next time we do this, we're going to have another strike probably, because the company's going to be in even worse shape. So that is not the path to success. The path to success is working together. As part of that, I could definitely see outreaching to ERGs as a part of that. This strike impacted you, and we want to have a strong relationship with you. And one of the reasons the ERG exists is to create a space that is about belonging and feeling like this is a good place to work. That's what we want to double down on in this environment post-strike. So I don't know if I answered the question, but that's my sort of knee jerk on where does an ERG fit kind of like post-strike.
Yep, you definitely did. And this has just been an incredible conversation. I just cannot thank you enough for joining us. Clarity. This is not the specialty of most folks within the space. You also mentioned that you have a book, which I have. I don't know why I didn't have it next to me, but I have the book. It's an awesome book. And that's why I tell people how to find you, how to connect with you.
I'm on LinkedIn, which is where you found me. PB Wilson is my tag name there. The book is called The Leader Shift Playbook. It's available wherever you buy books, or you can go to yourleadershift.com and you can get a free chapter from it and learn a little bit more about us. Those are the easiest two places to connect.
Okay. Again, can't thank you enough. I know we're at time. Thank you everyone for joining us. And just know the ERG movement is a place where we bring you the real, even if it's rough to hear. But the only way that we're going to be on track for long-term success is by making sure that we are within compliance. More to come soon. Thanks all.